My name is Christine Lai, and I'm the founder of Special Education Legal Fund. The Individuals with Disabilities Education Act, or IDEA, promises every child a free, appropriate public education, often called FAPE. But what happens when the process breaks down? Today, I'm going to talk about what families can do when the special education system fails them. Because knowing the remedies is often the difference between a child receiving support that they need and falling through the cracks. The 6-step special education process follows a structured pathway: referral, evaluation, eligibility determination, creation of an individualized education plan, the IEP, instruction and monitoring, and annual review and reevaluation. This process is designed to ensure that students receive appropriate services. But in reality, problems can arise at any stage of this process. And when they do, families must understand their rights. The first step is referral, identifying that a child might need special education services. But sometimes the process stops before it even begins. Schools may ignore written concerns from parents. They may refuse to conduct evaluations, or they may fail to complete evaluations within the required timeline. Federal law requires evaluations to be completed within 60 days or sooner, depending on some state guidelines. When the timeline is not followed, parents have a right to challenge the delay because early identification is critical. Every missed month or week can mean a lost opportunity for development. Even when evaluations happen, disagreements can often arise. Parents may believe that the school's evaluation is incomplete. For example, the district might conduct only a psychoeducational evaluation when the child also needs speech and language testing or an occupational therapy assessment. In these situations, families have a powerful safeguard. It's called an independent educational evaluation, or an IEE. An IEE allows parents to request an evaluation paid for by the school district by a qualified professional who does not work for the school district, at the school district's expense. This safeguard ensures that the school system is not the only voice in determining a child's needs. The IEE is one of the most important legal safeguards that parents have in the special education system. If parents disagree with the most recent school-based evaluation, they have up to 2 years to request an IEE based on that disagreement. Another common breakdown occurs during the eligibility decision. A student may be found not to have a disability, to have a disability but no educational impact, or to have a disability but not require special education services. When this happens, the denial must be provided in writing through prior written notice, and parents have the right to challenge that decision. Even when a student qualifies for services, problems can still arise. IEP goals may be vague. Sometimes they're not SMART, specific, measurable, achievable, realistic, and timely. Services might be inadequate. They might not be getting enough therapy or support. Transition planning might be missing. Or the specialized instruction may not truly address the child's needs. The IEP is supposed to be a living document, one that adapts as the child grows, but too often it becomes static. Parents must carefully review meeting summaries and document disagreements, because silence in these meetings can easily be mistaken for agreement. Even the best IEP means nothing if it's not implemented correctly. Sometimes services in the plan simply aren't provided. Maybe staffing is an issue. Sometimes the school can't find the appropriate provider or can't hire the right person for the job. Other times, schools modify services without parental consent, or they fail to track progress towards goals. This is why IDEA includes something called procedural safeguards. These safeguards guarantee rights such as parental consent before evaluation, access to educational records, and prior written notice before major decisions are made. These rights ensure that families remain active participants in the process, not passive observers. But what happens when these safeguards still fail and the system still doesn't work? In that case, there are formal legal remedies. The first step is often simple. Start a dialogue with the school. Reconvene your meeting, your IEP team for a meeting. You can try mediation. But if those steps fail, families can pursue more formal legal options. The first such option is the state complaint. All states have a mechanism whereby parents can file their grievances with the state education department. If the school violates procedural rules, parents can file a complaint with the state education department, and the state must investigate and determine whether a violation occurred, usually within a specific time frame, like 30 days. If the state finds in the parent's favor, the district must make changes to ensure compliance. The state complaint can be very effective when there are systemic issues affecting multiple students. The second legal option available to parents is a due process hearing. When families disagree about a school's decision about services, eligibility, or placement, they can request a due process hearing. Disputes between families and school districts don't go through a criminal or civil court system like the system that handles most other complaints between parties. Disputes between schools and parents go through a separate process, the due process hearing. The due process hearing is a formal legal procedure. An impartial hearing officer reviews evidence and testimony from both sides. Both parties, parents and schools, can present witnesses and cross-examine evidence, and the decision is legally binding unless it's appealed. It is essentially the courtroom of special education. The special education system is complex, but parents are not powerless. When problems arise, families can request evaluations, obtain independent assessments, challenge eligibility decisions, file state complaints, and pursue due process hearings. These remedies exist to protect one fundamental promise, that every child deserves access to an education that meets their needs, not just in theory, but in practice. So the next time a parent sits at a kitchen table surrounded by paperwork, wondering what to do next, I hope they remember this. The system may be complicated, but the law is clear. Children with disabilities have rights, and when those rights are understood and exercised, the system can begin to work the way it was always meant to. Thank you.